Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, Texas, we actually get to talk about you again. Listen, twice in 2 weeks. We don't get to talk about Texas very often because, well, they do a pretty good job of letting their state live free like, Americans. Now, the video we did a couple of weeks ago, thank you to everyone who geeked out on that, talked about a bunch of absolutely lunatic gun control ideas kicking around in your state capital. It also said that the likelihood of any of them actually becoming law was incredibly remote. Today, we're going to talk about a bill that's going exactly the opposite direction of our previous video, and that is Texas House Bill 162. It is a bill which would repeal Texas red flag laws. Now, while I know a lot of you are jumping for joy and going, that sounds awesome, we're going to slow it down a little bit. We're going to break it down so you understand what it does. And then we're going to talk today about, did Texas perhaps miss an opportunity? So today, let's spend a few minutes and let's talk about the anti-red flag law coming from Texas. Okay, Texas and America, here's what we're talking about. We are talking about Texas House Bill 162, sponsored by Representative Briscoe Cain out of Deer Park. Cool bill, even cooler name. Obviously, right now, Representative Cain is in first place for the coolest name of any state legislator nationwide. I also like the bill because it's very, very brief. It is only about 3 pages long, and essentially this is what it does. Texas is it's going to redefine what an extreme risk protection order or red flag order really is. It's going to severely limit what is actually an enforceable red flag. And then it's going to make enforcement of anything that lies outside of that law an actual criminal law violation. So without further ado, let me just explain first, how is the statute going to define a red flag or extreme risk protection order in the event that this becomes law? Extreme risk protective order means a written order, warrant, or executive order issued by a court or signed by a magistrate or other court officer that, okay, so this is the only thing that's going to be considered an extreme risk protection order now if this becomes law. 1, prohibiting a person from owning, possessing, or receiving a firearm, or 2, requiring a person to surrender a firearm or otherwise removing a firearm from a person, and this is really important, B, is not issued on the basis of conduct that resulted in a criminal charge for the person who is the subject of the order. So the days of a neighbor making an allegation, a soon-to-be ex-spouse making an allegation, or something like that, which results in no criminal charges whatsoever, cannot be the basis of an enforceable extreme risk protection order moving forward if this bill becomes law. Now, of course, if you have been charged with a crime that would be so severe, Texas, I'm sure, has mechanisms in place in which a person would be disarmed at the time of arraignment, pending the outcome of that case if it's an allegation of a violent or serious violent offense. So they would still have the ability to disarm people who are charged with very serious crimes. But the typical type of application we see in red flag laws, that is a neighbor dispute, a soon-to-be spouse dispute, a sibling dispute, a professional dispute, something like that, those would no longer be able to be served on individuals in the state of Texas because it would actually be criminal conduct. Because the punchline to the statute is that the criminal conduct is the following. A person commits an offense if the person serves or enforces or attempts to serve or enforce an extreme risk protective order against the person in this state unless the order was issued under the laws of this state. And by the way, the violation of this law would be a state felony. Now, who does it apply to? It applies to everybody in law enforcement. Very, very broad application. The bill specifically states that if enacted into law, the law applies to the state of Texas, including any agency, department, commission, bureau, board, office, council, court, or other entity that is any branch of state government. 2, the governing body of a municipality, county, or special district or authority. 3, an officer, employee, or other body that is part of a municipality, county, or special district or authority, including a sheriff, municipal police department, municipal attorney, or county attorney, and 4, a district attorney or criminal district attorney. Okay, so all of that sounds really good, but I think that Representative Kane may have gone just a bit too far, and if someone wants to get this video over to him, what I would encourage you to do is watch what happened in Missouri with their Second Amendment Preservation Act, because I do believe that everything that I've read so far really creates no problems at all if the Texas state legislature approves it. However, in kind of a chest-puffing, football-spiking, perhaps unnecessary move here at the current time, the representative added additional language into the bill, which reads, certain federal laws unenforceable. A federal statute, order, rule, or regulation purporting to implement or enforce an extreme risk protective order against a person in this state that infringes on the person's right of due process, keeping and bearing arms, or free speech protected by the United States Constitution or the Texas Constitution is unenforceable as against the public policy of this state and shall have no effect. And that's exactly what the state of Missouri did in their Second Amendment Preservation Act, and ultimately got it chucked out on federal supremacy. So, not that I'm part of the Texas state legislature, not that anyone in Texas wants to listen to what a Washington state attorney has to say, but if you want to pass this bill, you might want to just excise that out of the bill, maybe put it somewhere else, see what happens with that. But this bill could be subject to federal challenges with the inclusion of this language. Okay, and then I said earlier that, hey, why at first blush this seems like a great idea, is Texas perhaps missing an opportunity? Let me explain what I'm talking about, okay? When we talk about red flag laws on this channel, when I hear people talk about red flag laws on other channels, I don't see anyone disputing the fact that there are some people who clearly demonstrate that they should not be armed. And that if they are armed, they in fact, without a doubt, will be a danger to themselves or others. Now, I think that category of individuals is much smaller than what other people claim it is, but I think we all, especially those of us that have worked in the criminal justice system, have come across those people on numerous occasions. The problem that I and many other people on this side of the fence have with red flag laws is their implementation. Because there is not any shred of anything that resembles procedural due process before we strip a person of what is supposed to be an inalienable right. In many jurisdictions, it is by declaration only. Temporary orders are issued ex parte, which is a fancy way of saying the judge only heard from one side of the table, okay? Then when you get to the actual full-blown hearing on the merits, there really isn't a hearing on the merits, because oftentimes the people who are trying to defend people of these are left having to try to what? Cross-examine a piece of paper. So from a procedural due process standpoint, red flag laws absolutely positively crumble. And while I know some of you may believe out there that any gun law is unconstitutional, if we are going to disarm individuals, and we're going to disarm individuals for valid reasons, there needs to be a procedural mechanism in place which absolutely positively secures the constitutional rights of the accused. I think everybody can agree on that. That is not a conservative or liberal issue. If ever there was a state that could have perhaps reworked their red flag laws so that it could serve as a model for, hey, listen, if we do have dangerous people, if we do have people that are losing their mind, if we do have people that are so deep into the depths of addiction that they are a danger to themselves and others by having access to firearms, which that does happen in reality, we have a mechanism in place to disarm them, but that mechanism absolutely positively ensures their constitutional rights are protected. What am I talking about? I'm talking about a full hearing on the merits where witnesses are actually sworn in and they take the witness stand and they're subject to cross-examination. And the respondent has the ability to put on their own evidence and to offer their own expert opinions and things like that. Something much more akin to when we strip people of all their other rights, including their right of freedom, before we send them to jail. Listen, we'll see if this bill goes anywhere. Once again, it is Texas House Bill 162. We're going to link it up down below so that you guys can geek out on it for yourself. Kudos to Representative Kane. I think he's got his heart and mind in the right place. Listen, if you got any more questions about this, or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool. Tell us all about it by clicking on that link right there. If you just want to subscribe to our monthly newsletter, the ability to do all of that is right down there in our description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.